Look, time keep ticking, I've been listening, but it don't talk back. Yeah. I done gave my youth to the grind, and my soul feels older. Back when dreams felt close, now they sit on my shoulder. Whisper keep going, but doubt get louder. Every missed call from fate feels like lost power. Mama said patience, but patience feel like prison. When you see the clock move, but your life feel missing. I done prayed for signs, got silence instead. Now I read between lines that was never there said. Used to think success was a chain full of gold. Now I see it in peace when your heart stay whole. But it's hard when your past keep knocking at night, and your future look blurry, no lens, no light. I've been chasing validation from a world so cold, trying to fill up a space that can't be controlled. If time is money, why I feel so broke? Spent years on hope, now I'm losing the quote. Time owes me answers, I've been waiting too long. Singing pain in these verses, turning hurt into song. If I lose it all today, would I still be strong? Or just another lost soul trying to right these wrongs? Yeah, time owes me answers. Yeah, I'm calling it out. All these years in the dark, now I'm drowning in doubt. But I still hear a voice say, don't give up now. So I walk through the storm with my head unbowed. Had a friend turn ghost when the money got thin. I question every smile, every brother, every friend. Seen love turn cold over pride and ego. Now my heart stayed guarded like a locked casino. I remember nights I was staring at the ceiling. Ask God why the pain got a permanent feeling. Why the real ones struggle, why the fake ones eat. Why the truth sound quiet, but the lies sound sweet. I done lost myself trying to be what they wanted. Now I'm looking in the mirror like, who really on it? Is it fear of failure or fear of success? Either way, both paths feel like too much stress. Time don't pause when you fall behind. It just keeps moving, never reads your mind. So I write these lines like a therapy session. Every bar confession, every breath a lesson. Me answers. I've been waiting too long, singing pain in these verses, turning hurt into song. If I lose it all today, would I still be strong? Or just another lost soul trying to right these wrongs? Time owes me answers, yeah, I'm calling it out. All these years in the dark, now I'm drowning in doubt. But I still hear a voice say, don't give up now. So I walk through the storm with my head unbowed. Maybe the answer ain't time, maybe it's me. Maybe I'm blind to the things I can't see. Maybe the pain just part of the growth. Maybe the silence the loudest note. I've been running from truth, but it caught up quick. Like a shadow in the night, always part of this. Had to sit with my thoughts, let the demons speak. Now I'm stronger every time that I feel weak. If time on me answers, I collect them slow. Through the highs and the lows, yeah, I let it show. That the man I become worth more than gold. Not defined by the stories that I've been told. I ain't perfect, I'm learning, I'm still in the race. Trying to find real peace in a temporary place. And if time never answers, I'll still stand tall. Cause the journey itself was the answer all along. Maybe time don't owe me nothing. Maybe I just owe myself.
Greetings, greetings, greetings. I'm King Clifford Jefferson, ascendant of Godfrey, the fifth caravan Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know as the Vicar of Christ, or Melchizedek, or the King of Righteousness. It is July 2nd, 2026, which is equivalent to the Berber year 2976. I greet you in the name of my Queen Sister Galveston from the House of Galveston. I greet you in the name of all our ancestors, our predecessors, our successors. I greet you in the name of you, all those who are striving to get an understanding of what it is that we are here and called to do in the present day. This lecture is a long-awaited lecture, and it's called Supreme Court's ruling on the birthright citizenship. But they did not tell you, once again, but they're not telling you, pardon me. So Supreme Court ruling on the birthright citizenship, but they're not telling you. Okay? Very, very important that you take heed to this very lecture that I'm giving to you, as well as the platform that I'm on, because you won't get this information nowhere else. I know a lot of people like to talk, they don't like to show receipts, but I'm showing you not just receipts, but my analyzation of the receipts that I give in regards to declaratory and injunctive relief that we all seek in regards to us being citizens, because along with that citizenship comes an inheritance. All right, an inheritance right. They made a citizen, but where's our inheritance right that comes along with us? That's retrospective and not prospective, meaning that we retain these rights that were unimpaired, not the rights that were enumerated us by way of them passing legislations or codes, etc. All right. So all those who are out there listening, who goes have your specific platform where you go get your information, I I think you should diligently take a second look at where you get your information from, because all that you're taught is not the actual truth. So with that, we get started with this marvelous lecture. Just hold it for a moment. I got to take care of something. Once again, like, share, subscribe to your King, as well as to our website and platform, the Third Temple English Church of England. The Third Temple English Church of England, as well as donate free and common sockets to my Cash App, $ Clifford Jefferson L. Once again, $ Clifford Jefferson L. This is the information that's needed to make you aware of your civil status versus your political status, and which, according to the laws, we have none. Okay, but we do have a civil status, and it's important that you understand and learn how to separate the two. Okay, let's get started. This is Supreme. Let me come back here. Page 29. Okay. October term 2025. Let me show this. You're not going to get the breakdown nowhere else. You can go to the news, you can go to CNN, you can go anywhere you want to go in regards to analyzing the language of the common law. Okay, all right. Common law is common law, which must be looked at in light of the English history. So you got to start from the English history, or how history started in regards to the origin of what we call the common law. If you don't know that, then you don't know what the hell you're talking about. Okay, you don't know what you're talking about. October term 2025. We're not going to read the syllabus. We'll read the title though. Supreme Court of the United States syllabus, Trump, President of the United States, ETAL, versus Barber, ETAL. Circulatory writ before the judgment to the United States Courts of Appeals for the First Circuit. Docket number 25-365, argued April 1st, 2026, decided June 30th, 2026. The question presented is whether the Constitution guarantees citizenship to children born in the United States of parents who are unlawful or temporarily present in the country. So that's specifically dealing with a narrow question, all right, whether the children born within the United States of parents who are unlawfully or temporarily present in this country. All right, that's the question before the Supreme Court in regards to this dissent, as well as to the judgment order of the Supreme Court. Okay, the only thing that they're questioning, not questioning anything else, that needs to be understood. Okay, under the Citizenship Clause of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. That's the plain language of the 14th Amendment, which made the emancipated slaves citizens. Okay? That was the original intent for the federal enactment of the supreme law of the land, now known as the 14th Amendment. It's not needed for our salvation, but nonetheless, we're going to talk about it. So under the Citizenship Clause of the 14th Amendment, all persons born or naturalized in the United States is subject to the jurisdiction thereof and are citizens of the United States and of the states wherein they reside. So they're talking about jurisdiction. That means the same language as power, authority, allegiance means the same thing. Okay? Jurisdiction means the same thing as power, the authority, the allegiance, or allegiance. Okay? Very important. They're synonymous in this aspect. On January 20th, 2025, the executive officer, President Trump, issued an executive order number 14160, titled Protecting the Meaning and Value of an American Citizenship. Protecting the meaning and value of American citizenship. Okay? He's not a citizen. He's acting in his official capacity in the public forum. So he's a trustee. He's acting in the capacity that's not private. So he's not one of the people that they're talking about. Okay? So President Trump issued an executive order number 14160, titling Protecting the Meaning and Value of American Citizenship. The order provides that children born, and we're looking at the plain language of the order, okay? This is an order. The order provides that children born in the United States of parents who are unlawfully or temporarily present here are not subject to the jurisdiction of the United States and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act, which uses the same language, okay? That will be Title 8, United States Code, Section 1401, okay? The district court agreed provisionally, certified a nationwide class of children who would be denied citizenship by the order, and preliminarily enjoined the order enforcement. This court grants a writ of certiorari before judgment. What was held? Children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment Citizenship Clause. So according to the Supreme Court, it is held that unlawful parents who are temporarily sojourning here, all right, and they have children born on the soil, they are in fact considered to be United States citizens for the purpose of naturalization in regards to what we call jus soli. Not just sanguineous, jus soli. Very important that you understand that. This is how they're looking at it from prospectively in the eyes of law, going forward, not backwards. Okay? The Citizenship Clause must be understood in light of its historical context, from the English common law to the widespread condemnation of the court's decision in the Dred Scott versus Sanford. Okay? So they take their cue from the English common law to the widespread condemnation of what affected only the emancipated people identified as Negro, blacks, and colors because of the effect this case had on the nation as dissented by Chief Justice Taney. Okay? Very important to understand how the impact of Dred Scott versus Sanford affected only the people identified as blacks or Negroes. Okay? No other person did it affect to the degree of in regards to the intent of the 14th Amendment. All right? Let's continue. It's the second page. Under the English common law, not the American common law, but the English common law, children born within the sovereign dominions owed a natural allegiance to the sovereign who protected them at birth. Now, this is not talking about domicile. It's only talking about an allegiance, meaning respecting the authority, the power, the allegiance, or jurisdiction of that sovereign power, which at this particular time under feudal law, which at one time was under English law, goes back to the time of the monarchs. Okay? This is why they're referencing English common law. This is why they're referencing William Blackstone's commentary on the laws of England, where the common law descended down from. Okay? Very important. Regardless of how monetary and uncertain their presence, such children were therefore natural born subjects. Natural born subjects. The same rule applied to children born of parents subject to exposure. The rule's exceptions were narrow children born in lands the sovereign did not control, children born in areas temporarily outside the sovereign's control, and children of foreign ministry by fiction of extraterritoriality. Okay? Meaning not being within the jurisdiction of the king. Okay? Whether it's on the soil or either of the overseas possessions or even if you're born abroad. Okay? You have a political status and a civil status that you were born with. Okay? Whether you exercise both of them is yet to be determined. And it needs to be determined by what? The common law of England and looked at in light of its history. This is from Juan Kimmel Art case with the Supreme Court and the decision in regards to the writ of circulator depending on heavenly, okay? In lieu of historical fact, but didn't need that to decide this case, all right? This common law of citizenship, now known as jus soli, okay, or rights of the soil, crossed the Atlantic, and prevailed in each and all of the states after American independence. Kent's Commentaries on American Law. The rule was applied even to the novel situations of quasi-sovereign Indian tribes, who maintained dominions of their own such that Indians born under their dominions were not citizens but members of aliens and sovereign tribes. In A Nation of Immigrants, Jeux Soleil's broad scope took on a particular importance and showed that children of foreigners, including those here, are temporary sojourners, okay, would be American citizens by birth alone. Okay, that's very important to understand that because Benjamin said the purpose of the Naturalization Act of 1790 was to make naturalized citizens of foreign aliens. Okay, this is what Benjamin Franklin said. Let's go to that proof. So, in order to understand citizenship, it must be looked at in light of the common law of England. It must be looked at under the common law of England in light of England's history. Okay, and England's history starts from 927. Okay, very important. This is the observation concerning the increase of mankind, people in the country in 1751 by Benjamin Franklin. Okay. Observation concerning the increase of mankind, people in the country. It's a short essay written in 1751 by American polymath Benjamin Franklin. So we got the source. The essay examines population growth and its limits, writing as, at the time, a loyal subject of the British Crown, not the English Crown, but the British Crown. Franklin argues that the British should increase their populations and power by expanding across the Americas, taking the view that Europe is too crowded. This is what Benjamin Franklin said, that the British Crown, and he said he was writing as a British subject at the time. Right here. Where's it at? Oh, come on. Bear with me. My screen. Bear with me. My screen shut down. Come on. Where is mine? Here we go. Sorry about that, everyone. Where was I at? I was right here. Judicial. Where did it go? Here we go. Context. Franklin projected exponential growth, doubling every 25 years, in the populations of the 13 colonies, so that in a century the greatest number of Englishmen would be on this side of the water, thereby increasing the power of England. As Englishmen, they would share language, manners, and religion with their countrymen in England, thus extending English civilization and English rule substantially. Okay? Right? But he just said right here, the essay examines population growth and its limits, writing as at the time a loyal subject of the British Crown. He wasn't an English subject of the English Crown. He was a subject of the British Crown, and the British Crown and the English Crown are different, two different body of politics. Very important. And he was talking about British Crown coming to America, not the English Crown coming to America, but the British Crown. Okay, because they said that Europe was too crowded. Okay, coming over to where the 13th colony, but he was a British subject, and he talking about Englishman, but he was not an Englishman because you must understand the nationality of the English. Okay, very, very important. Let's get in. So we just said he was a British subject at the time, and he was rooting for more British settlement here in the 13 colonies, identifying himself as what they call Englishman. But that is in fact a lie. Let's go to the case law from the Supreme Court. Let's go to page 30. We don't want to read the syllabus. We just read a little bit. Okay, listen to we didn't read the syllabus, but we're going to read and coming down to the order, then we'll read some of the concurring dissent from some of the justices to support the ruling, okay? But we're going to read the actual ruling right here. We're going to sum up what the ruling said. This is the opinion of the court. For the dissent in the government, Wang Kim Ark is essentially irrelevant. So they did not use Wang Kim Ark to decide this case, even though Wang Kim Ark is the leading case in regards to establishing the true intent of what citizenship means and the origin where they should look to in regards to the origin of citizenship via the 14th Amendment. All right. So it said, but for the dissents in the government, Wang Kim Ark is essentially irrelevant. They attempt to narrow that precedence they attempt to narrow that precedent by noting that the court's opinion repeatedly referred to the domicile of Wang Kim's parents. Okay, that is true, but the reasoning underlying the holding of Wang Kim Ark cannot be squared with a domicile requirement of the sort of government envisioned. Bucklew versus Precise. As we have already explained, the court exhaustively canvassed the text and history of the Citizenship Clause. It traces an unbroken line from English common law and through the founding and antebellum eras and through the debates to the clause ratification. Okay? So they did the research already. Yet at no point did the court identify any evidence in historical record that the ratifiers of the 14th Amendment thought themselves to be imposing a domicile limitations. So at this time they were in limited domicile limitation because at this time it was not retrospectively it wasn't a thing. Okay, it was not even considered in regards to domicile because based upon the history of where citizenship comes back, based upon the origin of the common law of England, it was based upon your allegiance within the king's dominion. Okay, that's what it's based upon, and that determined your right to a civil status, let alone a political status. In the end, it is the dissent of Wang Kim Ark that makes the strongest case for a domicile-based theory of American citizenship. Okay? So they still depend on Wang Kim Ark, but nonetheless they didn't need it to decide this case because it wasn't based upon the true origin of the common law where citizenship stemmed from via the parties that were referenced in this particular case. Okay? Which that means will be the respondents. It said there Chief Justice Fuller resisted the application of the English common law rule because it recognized no exceptions in the instance of birth during the mere temporary or accidental sojourning of parents. Okay, so English common law rule didn't apply because they recognized that if you were not within the jurisdiction, they did not have the authority to hear the matter. Okay. He admitted that in England, the question of domicile is entirely distinct from that of an allegiance because the one relates to the civil and the other to the political status. Did you hear that? He admitted that in England, the question of domicile is entirely distinct from that of allegiance because the one relates to the civil and the other to the political status. Okay? Very important. Majority of you don't understand that right there. But he believed that a different view as to the effect of permanent abode on nationality had been expressed in this country. Okay? Permanent abode. That's civil status. That is not political status. Domicile is civil status. Political status is allegiance. You must understand that. Under this different view, the 14th Amendment prevents the acquisition of citizenship by the children of aliens whose parents own a local and temporary allegiance, merely remaining subject to another foreign power. The government and today's dissenters agree, but the bill commanded only a dissent in 1898, and neither time nor circumstances has that changed the fact that it is not the law. So they agreed that you were not subject to the jurisdiction if you're not subject to the king's protection, if you're not subject under the king's allegiance, being in the king's under the king's jurisdiction, and if you wasn't within the king's jurisdiction, then that means that you were subject to some foreign power, and you didn't have the right to that protection under the what we call allegiance, i.e., your political status, let alone your civil status, because you got two. It just said two. Okay, one relates to the civil, and the other your political status. Juan Kim Ark said it too, and this is not the Juan Kim Ark case. This is the case that's here in 2026. Saying the same thing. Again and again, dissent casts the common law as a feudal medieval and a remnant of the darkness of the Middle Ages. Okay? Opinions by Judge Thomas, and Judge Gorsuch, which we'll review in a little while, as well as Judge Alito. Okay? So we'll look at their dissent and touch on their dissent in a second. Hold that thought. It says that was not the view of the Reconstruction Congress, where the dissent see feudalism. The framers of the 14th Amendment saw emancipation. So there was two different views in regards to the framers thought, as well as the Reconstruction Congress. Okay, the Reconstruction Congress at the time of the Revolutionary War was not about emancipation. It was about their suffering under what they call feudalism. When they got around to the framers of the 14th Amendment, it switched to what we call emancipation. Okay, very important to understand this time frame. Okay, in regards to feudalism and emancipation, because feudalism and emancipation still denotes some type of servitude. Okay, whether you're talking about servitude going all the way back to 1066 with William the Conqueror, where the origin of feudalism stemmed from, or were you talking about dealing with the 1865 when we were emancipated as a result of us being property by monarchs, okay? All right, which was still practicing under feudal law because the feudal law didn't end until modern day amended it under New Jersey Revised Statute 46:3-2, okay? I mean, 1, 46:3-1, feudal tenure abolishment going back to Charles II, 1660 Act, okay? So it says, by the time of the Glorious Revolution in 1688, in fact, the tie created by birth was less a duty than a right. The foundation of the ancient liberties of free-born subjects, H. Muller subjects, and sovereigns. That is why Blackstone describes the privileges owned to the natural born. That is why the colonists demanded the rights of Englishmen more than 250 years ago. Okay? Once again, the colonists demanded the rights of Englishmen in regards to whether you're talking about emancipation or whether you're talking about feudalism. That remedy came through the English common law, which according to Juan Kim Ark must be looked at in light of the English history, which goes all the way back to 927 AD. Okay, that's very important. And Brother Douglas just said that he was a British subject, but yet he wanted the British to settle here, come here, and set up shop. Okay, and then all of a sudden now rebel against them because they didn't like their ways. Okay, you should have thought about that before you let them come here. Okay, now realizing that the capacity and the authority, the jurisdiction that was here at that time was governed under what we call the Crown of England. That is very, very important to understand that. Why? Because the citizens or subjects that were here were English subjects. Okay, yes, the Negroes, the blacks are the English subjects. This is your civil status, okay? You didn't have any political status till they created the 14th Amendment. But you had your civil status, which is what I'm trying to teach you because it was preserved from your ancestors. How we know it? Let's go back to Juan Kim Ark. All the way back to 1886, okay? The Juan Kim Ark case. Let's go there. (1898) case, page 8. Before we do it, let's close out on that one part. Let's go back there. So it says, that is why Blackstone describes the privilege owed to the natural born. That is why colonists demanded the rights of Englishmen more than 250 years ago. And that is why abolitionists lauded the ancient universal rule of citizenship by birth alone as an ordinance of heaven. Did you hear that? Abolitionists declared it as an ordinance of heaven, going back to Leviticus 25:50. Parts of Leviticus 25:10. Citizenship then and now was the right to have rights to freely participate in our political community. All right? Political community. Not your civil status, your political status. They're totally different, but yet you had two, as we just read. Okay? You had two. The framers of the 14th Amendment extended that promise to every freeborn person in the land. What did they extend? Their political status in the political community, but not the civil status, because the civil status remain to us who are those who are permanently domiciled, okay, before their stuff got started, okay. Citizenship then and now was the right to have rights to freely participate in our political community. The framers of the 14th, not a community that was there prior to that, but a community that came after, a community they established, okay? And according to their community, if you wasn't white, you were not allowed under the Naturalization Act, okay? The framers of the 14th Amendment extended that promise to every freeborn person in this land. We keep that promise today, okay? This is the 2026 case we're reading. The judgment of the District Court for the District of Hampshire is affirmed. It is so ordered. So it was ordered that a person whose parents were not lawfully domiciled, if that child is born on the United States soil or in the territories of the United States or born abroad, you are still, in fact, a citizen. Why? Because of your allegiance, because of that power, because of that sovereignty, i.e., because of that jurisdiction, meaning the same thing. So they're saying they are, in fact, the sovereigns, okay? They determine who can be a citizen and who cannot be, okay? But it must be conformed or not be ultra-virus to the intent of the Constitution, okay? But when we go to Juan Kim Art, the Constitution nowhere defines who a citizen is. How we know it? Let's go to Juan Kim Art. 1898 case. The Constitution nowhere defines the meaning. Let me go up more. Now remember, they wanted the rights of what? Englishmen. The 14th article of amendment, besides declaring that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside, meaning prospectively, meaning from this point on, okay? From this point on. What about those before you created this Constitution, okay? What about those people, okay? What about those who were enslaved at the particular time and didn't have no permanent domicile, okay? What about them? All right. It also declares that no state shall make or enforce any law which shall abridge the privileges or immunities of a citizen of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny it to any person within its jurisdiction the equal protection of the law. So this is talking about not just but civil protection, okay? This is talking about civil protection, due process of law, life, liberty, pursuit of happiness. This is called due process of law. You had these rights before the rights that they're talking about, which were the enumerated rights, stem from. You already had reserved rights, which are retained rights, which are rights that are unimpaired, which have nothing to do with the color of your skin. Okay? Very important. No state should deprive any person of life. That's an unimpaired right. That's a retained right. Liberty. That's an unimpaired right and a retained right. Or property. That's an unimpaired right and a retained right that they didn't give to you, because the ones they give to you, they're called enumerated rights, which means they wrote them down for you. Okay? And you can't be deprived of that without due process of law. But you can't get due process of law if you're not within the jurisdiction, i.e., if you're not under the power, if you're not under the sovereignty, if you're not under the authority, or if you're not in the allegiance thereof. Okay. Okay, so because it says without due process of law, nor deny any person within its jurisdiction the equal protection of the law. Very, very, very important for you to understand that. And the 15th Article of Amendment declares that the right of a citizen of the United States to vote should not be denied or abridged by the United States or by any state on the account of race, color, or previous conditions of servitude. You see that? Previous condition of servitude. They're talking about your political affiliation, not your civil status. This needs to be turned to you. Why? Let's see why. Right here. The Constitution nowhere defines the meaning of these words, either by way of inclusion or of exclusion, except insofar as this is done by the affirmative declaration that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And this, as in other respects, it must be interpreted in the light of the common law, the principles and histories of which were familiarly known to the framers of the Constitution. Now we got a problem because the understanding of the common law of England and the history of the common law of England is distorted when you listen to it from the point of view of the framers, as we see in the same case we're reading, Juan Kim Art. Their understanding is missing a big ass gap of history going all the way back to the folk right that we had that was ancient, unwritten down. It was a customary tradition. It was called bookland. Okay, so these were traditions and customs that we retained that are unimpaired because they were given to us by our lords, which we call gods. Why? Because they're no longer here anymore. Okay, so these are our gods, our lords that we depend upon. In Smith versus Alabama, the language of the Constitution, as it had always as has been well said, cannot be understood without reference to what? The common law. Okay? The common law. The Constitution does not, in words, say who shall be natural born citizens. Did you hear that? The Constitution does not, in words, say who shall be a natural born citizen. That's why they created the Naturalization Act of 1790, because the Constitution does not say who would be a citizen. So that's why they declared that the only people can be citizens in 1790 were those who had the color of skin of white. Okay? Very important. We didn't come into the picture until they created the 14th Amendment, which had nothing to do with the color of skin, but your civil status, okay? Your parts of not your civil status, your political status, because they made you a part of the body of politics, but no civil rights because they're not dealing with equity. We know that. So it's clearly dealing with citizenship, a natural born citizen. It clearly points resort must be had elsewhere to ascertain that. And he proceeded to resort to the common law as an aid to the construction of this provision. Okay? So for the citizenship, in regards to who could be a citizen, you must look to the common law of England for that. And in England, they never used the word citizen. The term was called subject. All right? The term was called subject. In Smith versus Alabama, Justice Matthew delivered the judgment of the court and stated that there is no common law of the United States in the sense of a national customary law distinct from the common law of England as adopted by the several states, each for itself, apply as its local laws and subject to such alterations as may be provided by its own statutes. So it says its own statutes. So let's look at some of those common law that has now been coded into what we call statutes in 2026. Let's look at them. So let's look at some of those same laws. You need to be writing this stuff down. Like, share, subscribe. I'm telling you what they're not telling you. Certain tenures and holdings turn into free and common soakers. This means allodial. Why is it termed free and common soka, which is the allodial land, because it switched from feudal to free and common sokas, Ayalodo, meaning that it went from the feudal era all the way up till, which started in 1066, all the way up till March 12th, 1664. Okay, that is the time era of the feudal era. We see it right here in the statute. So everything from 1066 AD, okay, okay, right here preserved in one statute. Feudal tenures are abolished. Okay, it was abolished on March 12th, 1664. Okay, March 12th, 1664, then reaffirmed February 18th, 1795. Okay, feudal tenures were abolished. What is feudal tenure? How many of you guys know that? What is feudal tenure? Let's look it up. You have to have this capacity to understand this lesson. If you don't have this capacity, then it's going to go right over your head. We see the statues right here in New Jersey. Feudal land tenure in England. Hence the title. Feudal land tenure in England. Okay? And correlate that with the statute we just read. Oh, this is going to get good. Right here. High Middle Period. In England's ancient past, large parts of the rim were unoccupied. So when you think about unoccupied, think about this whole damn landmass, what we call North America, unoccupied, as they say. Okay? As the founding fathers or the colonists or the discoverers or the conquerors say, it was unoccupied. Okay? And on, so in England's ancient past, and this is in fact England, in England's ancient past, large parts of the rim were unoccupied and owned as allodial title. You hear that? We call that free and common soakage. When you say common soakage, it's the same word as allodial. It said, and owned as allodial title. The landowner simply cooperated with the king out of a mutual interest instead of legal obligation. It was not until the Norman conquest, when William the Conqueror declared himself to be the sole allodial owner of the entire rim, that the land tenures changed drastically. Okay? Why? Because no land without a lord. Okay? That's it. All right? So we go back to William the Conqueror. Let's hit this first. Allodial title. You see that? Let's see. Let's look up common soakage. Common soakage. Let's see what it says that is. We're talking about an inheritance as subjects under the common law of England, not citizens. That's a late term. We're going to say as subjects under the common law of England in light of the English history. But in order to find that light, you got to know the history. Many of you knew it, but forgot it. Okay, here we go. Soakage was one of the feudal duties and land tenures formed in the English feudal system. It eventually evolved to freehold tenures called free and common soakage, which did not involve feudal duties. Farmers held land in exchange for clear defined fixed payments made at specified intervals to a feudal lord. This is what you do now. It's called taxes. That's what you call taxes. Let's see. Quinipetors. Write this word down. Queen of Petoris. Passed by Edward I. Background. To have an interest in this estate, you must have the proper capacity. Prior to the Norman conquest of England in 1066, the Anglo-Saxon law of land succession was customary. Land or folk land, as it was called, was held in allodial title by the family clan, meaning the group collectively held the land. It was probably of little relevance when the titular head of the clan or family died. Traditional land probably continued to be held by the community. The exact nature of allodialism as it existed in Anglo-Saxon England has been debated, but to no definite end it has been argued that the Mark system, Saxon allodialism, was a highly idealistic social communitarian state. Let's go back a little further. I'm looking for something else. Hold on. Okay, so I said Sokus was allodial. That's what I said. All right. I said common Sokus was the same thing as allodial. All right. That's what I'm telling you. All right. So let's go back to the statute. So we know from 4603-1, all feudal tenure has been abolished, and that started from William the Conqueror all the way up to March 12th, 1664. All right. Then amended February 18th, 1795. As you can see, right here, modern day statute. So we don't have to guess about this. It's right here, cut and dry. Don't need to guess. All right. So when from 1066 all the way up till the year 2020, to the year February 18th, 1795, everything was feudal. Okay. And then it was abolished on March 12th and then affirmed again in February. Okay. And all things now were discharged of feudal tenure and become free and common sokas. Discharge of all feudal tenure. All feudal tenures were discharged, okay, from this one statute. We don't need no history book. We don't need no constitution. We don't need no case law. We got the very statute right here in 2025, okay? This is, but in order for you to have an interest in this capacity, in order for you to have an interest in property that's no longer subject to feudal laws, you must have the capacity, okay? Where did the capacity come from? Who gave the capacity? Because you were born with it, all right? This is your inheritance we're talking about. Statutory confirmation. Certain tenures and holdings now turn into what? Free and common sokas. Who did it? A king of England. The tenures of honors, manors, lands, tenements, or of hereditaments, or of an estate of inheritance at the common law. Right? What common law? The same common law that we're talking about in Juan Kim Ark, 1868, as well as in the Supreme Court of affirmation of the birthright citizenship will still be in effect in lieu of the origin where it stems from, in which how they got it, which is based upon the common law of England, and who was ruling at that time based upon the allegiance, sovereignty, power, authority, jurisdiction is right here, the King of England. or any other person or body politics or corporate that has the capacity that existed at any time before July 4th, 1776. Not after, but before. So if you incorporate under this statute, it gives you the capacity in lieu of the interest of property governed under the statute, and that had to be before July 4th, 1776. Why? Because it had to do with allodial land, which was allodial before it became feudal, and then they changed it from feudal from 1066 when William the Conqueror invaded England, and then in March 12th, 1664, as well as amended in February, whatever date that was, they changed it back to allodial, which we call folkright, which is another term for it. It's called free and common soakage. It's right there. Okay? All right? Let's confirm that free and common soakage is also allodial. Let's go down and see this statute. 2. Force is going to do that. 4. Force is going to do that. 5. Let's go there. There you go. Queen of Petoris. Okay? Queen of Petoris. That's the statue that the King Edward I passed in 1290. 1295? Queen of Petoris. All right? In regards to His Majesty buying and selling of land. Okay? Right here. That's the statute we're talking about that made everything allodial or free and common soakage, which is one and the same. We know it because when you go to the next statute right here, bah. The state of New Jersey confirms that these same inheritors are no longer feudal, but they remain free and common soakage, which is allodial. Forty-six country that says gifts, grants, and conveyances by state allodial. All gifts, grants, or conveyances made prior, not after, prior to, and then after July 4th. So this is prospectively, retrospectively, and prospectively, meaning before and after. So if it's before, those who came are not in that capacity before the statute was enacted. You don't have an interest in that capacity to inherit property or have an interest in property governed under Title 46 because your capacity to exist as a citizen came after 1776, okay, which gives you a different capacity than the citizens or subjects that were here prior to 1776, okay? Very important. These are the English people. This is why it said the founding fathers declared themselves as Englishmen because they wanted the retrospective benefits, inheritance, gifts, grants, conveyances that were preserved for those heirs who were descendants of these kings and queens through that statutory enactment of their notice ultima re. Children born abroad, okay? Very important, which we'll go through if I have time. All right? So all gifts, grants, conveyances made to and after July 4th, 1776 of an estate of inheritance, an estate of an inheritance, that one word says it all. An estate of inheritance by what? A letter patent under a great seal of the state or any other manner of the state, whether it's by the legislators thereof or by the commissioners or agents or forfeit of the states or any other lawful competent authority, okay, under the state shall be and remain allodial and not feudal, and shall forever be and continue in free pure allodium, only forever discharged of, once again, all feudal tenures and the instance thereof that's going all the way back to 1066 William the Conqueror, because that's when feudal tenures started. Back that far. Okay? Very, 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 very important. So if they say all land is allodial in the state of New Jersey, it's allodial in every state. Okay? How we see it, because the United States cannot guarantee that you have a look at it. Allodial title. This allodial title is your folk right. Okay. Allodial title constitute ownership of real property. That means land, buildings, and anything else that's attached to you. Right now, we ain't talking about buildings or fixtures. We're talking about the land. That is key, because this is the inheritance that's preserved in lieu of your interest as an heir because of the capacity that you were born to as an English man or woman. Therefore, you have the right to the allodial land and everything that sits upon it. Okay? Don't just settle for an estate or parcel estate. You want the land. Okay? You are the sovereigns. You deserve the land. We can prove it. It says it right here. That is independent of any superior landlord. So if you have in your possession a deed, you better make sure that deed denotes to allodial possession, because it just said allodial title is independent of any superior landlord. That means that what? You are the landlord. Allodial title is related to the concept of the land held in allodium, or land ownership by occupancy and defense of the land. So when you look at the term allodial, it must be confirmed by the capacity and interest as confirmed by Title 46 of the New Jersey Revised Statute. It might be a different statute in another state, but in New Jersey, 46-3-2, 46-3-6, 46-3-5 clearly denotes to allodial, which is free and common soakage, which is the land that belongs to heirs free and clear. But they said here, most property ownership in common law jurisdiction is what? Be simple. Why is that? Why is that? I'm going to tell you why. In the United States, the land is subject to the eminent domain by the federal and state and local government, and is subject to the imposition of taxes by state or local government, and therefore there is no true allodial land because it's subject to the eminent domain power. That is the power of the state or the federal government to take. That is where they get their sovereignty from. New Jersey capacity governs under Title 50, and their eminent domain power to take is under Title 20. Two different statutes, okay? Very, very, very important. But they're not citizens because if we read the Constitution, Article 1, Clause 1, Section 1-21, it clearly points out that all the privileges and immunities are within the, what we call, what's that term? What we call it? It's called popular sovereignties. We are the popular sovereigns, okay? That's Section 2 of Article 1 of New Jersey's Constitution. We are, in fact, the popular sovereigns, okay? All right? We have pure allodial interest in any land. Once again, we have pure allodial interest in any land. The only problem now is that we do not have the capacity. How do we get the capacity? This is what you brothers and sisters are missing. Let's go back to the case law. United States versus 1 Kim Art. There is no common law of the United States in the sense of a natural customary law, distinct from the common law of England as adopted by the several states, each for itself, applied as its local laws, and subject to such alterations as made by provided by its own statutes. We just read the statutes, we've seen the alterations, we've seen the provisions that were amended and changed that exist in 2026. All right, and they're still using the same laws of England. They even got the name of the King of England right there in the statute. So what are you brothers and sisters listening to? Because it's definitely not me. There is, however, one clear exception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact, you hear that? Necessarily influenced by the fact influenced by the fact that its provisions are framed in the language of the English common law and are to be read in light of its history. Did you hear that? It's history. So if you don't know the history of England, then could you understand the English common law? Okay, how can you? Let's see if we can pull out it. English. Let's see what come up. History of England. All right, we don't need to go back all the way to the Stone Age, do we? No, we don't need to go back that far. Okay, right here. Just this little paragraph. During the period, several rulers attempted to unite the various Anglo-Saxon kingdoms, an effort that led to the emergence of the Kingdom of England by the 10th century. Okay? By the 10th century, and then we come to the feudal era established by William the Conqueror in 1066. So there's a whole bunch of history between the 9th and 10th century that none of you know right now. And your citizenship depends upon that. I didn't say that's what the court just said. Right? That's what the court just said. So you must understand English nationality. What is English nationality? Let's see what Bede says. Now we know Bede created BC. Okay? We know BC is before the Common Era. He created that. All right, we know Dionysius Exiguus created AD, Annus Dominius, 1 AD, and he didn't create that till 525 AD. Bede created BC in 721 AD after him. So as we can see, according to the English national identity, okay, this is why Bede's ecclesiastical history of English people is very important, because he does not just deal with the AD, he created the BC calendar to backtrack, all right, all the events that happened in regards to all the invasions that happened on what we call England or Albion or Britain, etc. Okay, Bede recorded it, all right. According to some scholars, the national identity of the English as a people or ethnic group dominant England can be traced to the Anglo-Saxon period. Okay? In early AD 731, and the unification of the Kingdom of England in the 9th and 10th century established as its national identity. You hear that? As its national identity. England to be the oldest. Once again, where's it at? Oh, come on. Oh, boy. Where was that? Beads. Where? Okay. And it also states that similarly, Adrian Hastings considered England to be the oldest example of a mature nation, and it links the development of this nationhood to the Christian church and spread of written popular language to the existing ethnic groups. Okay, so we see that Bedes in 731 said that the history of the English people is relatively associated with the English church. Okay, and there's a whole story behind that that I ain't got time to talk about in spite of today's lecture, which I'll probably do that probably either tomorrow or the day after. So with that being said, in regards to citizenship, all right, as said in Mind Kim Ark, we must look to the English common law in light of the English history, okay, to determine the purpose and intent how citizenship is supposed to apply to a person, okay? The fundamental principle of the common law with regards to English nationality was birthed within the allegiance is also called legality, obedience, faith, or power of the king. The principle embraces all persons born within the king's allegiance is subject to his protection. Okay? This is what you now call jurisdiction. Same word. Children born in Eden of such aliens were therefore natural born subjects, but children born within the rim of foreign ambassadors or children of alien enemies born during or within their hostile occupation of part of the king's dominion were not natural born subjects because not born within the allegiance, the obedience, or the power, or as would be said at this day, within the jurisdiction of the king. You hear that? So the obedience or power is, as we say it today, is the same as jurisdiction. Okay? Once again, all right. It said, but the children born within its rim of foreign ambassadors or the children of alien enemies born doing within their hostile occupation a part of the king's dominion were not natural born subjects because not born within the allegiance, the obedience, or the power, or as would be said in this day, within the jurisdiction of the king. Okay? You do not deserve the king's protection. Let's continue. In Uday versus Uday, 1869 case, the point decided was one of inheritance. You hear that? Depending upon the question whether the domicile of the father was in England or in Scotland, he being either alternative a British subject, Lord Chancellor Hartley said the question of naturalization and of allegiance is distinct from that of domicile. I repeat, the question of naturalization and allegiance is distinct from that of domicile. Lord Westbury, in the passage relied on by the Council for the United States, begun by saying, the law of England and in almost all civilized countries ascribe to each individual at his birth two distinct legal states or conditions, one by virtue of which he becomes the subject of some particular country, binding him by ties of natural allegiance, in which he may be called his political status, another by virtue of which he has ascribed to him the character of a citizen of some particular country, and as such is possessed of certain municipal rights and subject to certain obligations, which the latter character is his civil status or condition of the individual, and may be quite different from what? His political status. Did y'all hear that? I don't think y'all heard that. Y'all need to read that again. Hold that thought, but read that again. It just said that in the Supreme Court ruling we read today. Read that again. It says the law of England and all almost civilized countries ascribe to each individual. Oh, we just read that. Okay. It goes on to say, and then while maintaining that the civil status is universally governed by the single principle of domicilium, the criterion established by international law for the purpose of determining civil status and the basis on which the personal rights of the party, that is to say, the law which determines his majority or minority, his marriage, succession, testacy, or intestacy. Okay? It depends upon your civil status. They did not give you your civil status. They cannot give you a civil status because you were born with it. Okay? You were born with your civil status. It is your capacity. Okay? Very important to understand that. This was stolen from you. The capacity was stolen from it because right here in this case law, they said they took it for themselves in lieu of the interest. They took the interest by taking over that capacity in lieu of Title 46, which we just read in New Jersey revised statute. Okay? Right here in this case law. Let's go right to it. Where was it at? Where is it at? Okay, here we go. It is. Okay, where? Page 24 in Wine Kim Art's case. Let's go to page 24. Now remember, just because the court denied Trump's ability to dissolve the 14th Amendment, that don't mean the legislative branch can't pass an enactment and to do away with it. Okay, so this is something he might undertake. Okay, so it's very important to understand the importance of the 14th Amendment, not in so much as we need it, but understanding why it was created is definitely needed. You know why it was created, but we do not need the application of the 14th Amendment in regards to our civil capacity. Hold that thought. Hello. I did it by mistake.
Oh, okay. Just making sure. All
right, Noble.
All right, bro.
One. All right, let's see. 24. Okay, right here. It says here. Give me 1 second. It says there is therefore little grounds for the theory that at the time of the adoption of the 14th Amendment of the Constitution of the United States, there as any settled and definite rule of international law generally recognized by a civilized nation and consistent with the ancient rule of citizenship by birth within the dominion. Nor can it be doubted that it is the inheriting right of every independent nation to determine for itself and according to its own constitution and laws what class of person should be entitled to its citizenship. So think about that. Okay? It just said it should be left up for their own determination of what class of person should be entitled to citizenship based upon the Constitution. So when you go back to the 1776 Constitution, we couldn't be citizens because according to the Naturalization Act of 1790, we didn't have that color skin. Okay? We couldn't use it. When you go to the 14th Amendment, it wasn't about the color skin. It was about the political status that they want us to be under, which did not denote to our civil status, which still put us behind the ball. Okay? All right. Now we need to understand that none of they could have enumerated for us on behalf of our protected rights would do the job. All right? Because what we're reading here, it says here, there is therefore little grounds for the theory that at the time of the adoption of the 14th Amendment of the Constitution of the United States, there as any settled and definite rule of international law generally recognized by a civilized nation and consistent with the ancient rule of citizenship by birth within the dominion. Nor can it be doubted that it is an inheriting right of every independent nation to determine for itself, and according to its own constitution and laws, which class of persons should be entitled to its citizenship. It says both in England and the United States, indeed, statutes have been passed at various times enacting that certain issues born abroad of English subjects or of American citizens, respectively, should inherit to some extent at least the rights of their parents. But those statutes apply only to the cases coming within their purport, and they have never been considered in either country as affecting the citizenship of persons born within our dominions. I wonder why. Let's read that again. Both in England and the United States. They just didn't say in England. They said in the United States, statutes have been passed at various times enacting that certain issues born abroad of English subjects or American citizens, respectively, should inherit it. So this is an inheritance right. To some extent, at least the right of their parents, i.e. your ancestors, because your parents are gone. Some of our parents are dead and gone, and some of our parents are dead and gone, so that would make these by right your ancestors. But those statutes apply only to you raising an argument in a form that has the jurisdiction to hear it, and that would be, in fact, a court of law. Okay? So if you're not taking those drastic measures, you're not taking any measures at all. Okay? Because this deals with an inheritance of us being English heirs and successors, being born abroad. If you're trying to say this is not England, which we can say it is, but if you're trying to say it ain't, we're still protected by Title 8 United States Code Section 1401 under what they call Children Born Abroad Act, which is the secularization of the notice ultima re. Once again, this law right here. De notis ultima re. Because this is the law that were passed in what? In the United States and England. Why? Because you're in the United States, which we call England. Same place. The notice ultima re, also known as the Statute Children of Born Abroad Act of 1350, was an English statute during the reign of Edward III. Not Edward I, not Edward II, but Edward III. It regulated rights of those born overseas. When you say overseas, that means born not within the territories of what we call the United States of America. Okay, that means you're born abroad. Okay, if you're not born in the United States or any of the United States territories, that means that you were born abroad, which makes you an immigrant or an alien until you can prove that you, in fact, have some type of allegiance to be considered a citizen here in what we call North America. So our ancestors passed laws way back in 1350 to preserve our civic status and our political status that was already confirmed by way of their notice ultima because it involved an inheritance going all the way back to the 100-Year War. Okay, the 100-Year Wars. Okay, and there was a bunch of cycle wars termed the 100-Year Wars. Okay, very very important. The act was called the Act of 1350. Okay, all right. They mentioned this act right here in the same case we're reading Juan Kim Art. Right here. It says both in England and the United States, indeed, statutes have been passed at various times enacting that certain issues born abroad of English subjects or of American citizens respectively should inherit to some extent at least the rights of their parents. That's domicile, not born in the soil, but that's domicile because domicile means place or abode. Okay, both these statutes apply only to cases coming within their purport. So if you don't raise it, you lose it. Okay, it's the reason why we're raising the argument saying that we are the lost heirs of the English people. Okay. The earliest statute was passed in America, United States, and in England was the earliest statute that they passed was by who? The reigning monarch Edward III and the Rules of Parliament in 1343. So that means in the 17th reign of Edward III, 1343, it is stated that before these times there have been great doubt and difficulty amongst the lords of the realm and in the commons, as well as men of the law and others, whether children who were born in parts beyond the sea ought to bear the inheritance after the death of their ancestors in England, because no certain law has been therefore ordained. Let's continue to read. This is the Juan Kim Art case we're reading. There was no manner of doubt that the children of our Lord the King, whether they were born on this side of the sea or beyond the sea, should bear the inheritance of their ancestors. And in regards to other children, it was agreed in this parliament that they should inherit whatever they might be born in the service of the king. That is allegiance, my brothers and sisters, let alone domicile. But because the parliament was about to depart and the business demanding great advisement and good deliberation, how should it be best or most shortly done? The making of the statute was put off to the next parliament because of what? The Black Plague. Okay? By reason apparently the prevalence of the Black Plague that was happening in England. No act upon the subject was passed until the 5th of Edward III in 1350. This is the notice ultima when Parliament passed an act entitled A Statute for Those Who are Born in Parts Beyond the Sea, by which after reciting that, some people be in doubt if the children born in parts beyond the sea out of the legions of England should be able to demand inheritance within the same legions or not, whereof a petition was put into Parliament of the 17th of Edward III, and as not at the same time wholly accepted, it was agreed and confirmed that the laws of the Crown of England is and always has been such that the children of the King of England, and whatever part they be born in England or elsewhere, be able to also bear the inheritance after the death of their ancestors. It will also agree that certain persons named, which be born beyond the sea, out of the legions of England, shall be from henceforth able to have and enjoy their inheritance after the death of their ancestors in all parts within the legions of England, as well as those that should be born within the same legions. And is further agreed, for itself, where was we at? Okay. It was further agreed that all the children inheritors, which from henceforth should be born without the allegiance of the king, whose fathers and mothers at the time of their birth be and shall be at the faith of the allegiance of the King of England, shall have and enjoy the same, you hear that, at the faith of the lieges of the king of England shall have and enjoy the same benefit and advantages to have and to bear the inheritance within the same legions as the other inheritance aforesaid in time to come. So always that the mothers of such children do pass the that do pass the sea by license and wills of their husbands. Okay, so this is an inheritance that was preserved whether you were on within the king's dominion, or within the king's territory, or abroad. Okay, the United States have taken the same position as if this same inheritance stems from them, which in fact it don't. Why? Let's just go to what the Supreme Court say and the Supreme Court decision by Judge Gorsuch. Okay, and then we'll close out on this. We're gonna go back to one Kim Art. We just want to uh, talk about what Justice Gorsuch said in the Supreme Court case in her small dissent. Where's it at? I'm missing it. Okay, here we go. Now, this is what Justice Gorsuch in her dissent stated. Very important. At the heart of today's dispute lies two competing views of the 14th Amendment Citizenship Clause. On one account, the clause incorporates the English common law rule of jus soli, literally the right of the soil. That rule, developed in feudal times, had more to do with being a subject than a citizen. It was based on the notion that a man's own personal service to the Lord of the soil, the same as his master owed it to the king, and it was born with the child and only ended in the grave. Okay? That was one view that the court took in regards to the 14th Amendment. Okay? This is a retrospective look, the origin where it really came from. Okay? But they didn't use the Wan Kim Ark because the Wan Kim Ark dealt with a matter in regards to a Chinese descent becoming a United States citizen and not based upon his domicile or his permanent domicile, which would not be an American citizen because he was from China. Okay? So we must understand that when we're dealing with what Justice Gorsuch said, we're dealing with the historical, broader scope versus the narrower, limited scope. Okay? It said, at the heart of today's dispute lies two competing views of the 14th Amendment Citizenship Clause. On the one account, the clause incorporated the English common law rule of jus soli, which is what Wan Kim Ark said. Okay? One can argue you must look to the history of the common law of England, point blank, okay? Not just the common law, but the legal fix, which is the statute law that were put in place that we just read. The Notice Ultima Re, Queen and Pretorius, the Notice Ultima Re, the Magna Carta, a lot of things that have been put in place by our forefathers, as well as the preserved revised statute we see here in New Jersey in 2025, 2026. Okay? Very important. They all apply in our capacity as citizens or subjects in lieu of the birthright, which is the interest governed under Title 46. Okay? So it says, the rules developed in feudal times, going all the way back to William the Conqueror, and had more to do with what? Subject rather than a citizen. Okay? It was based on the notion that a man owned personal service to the lord of the soil, the same as his masters owed it to the king, and it was born with that child and only ended in the grave. This is why it is cheated back to the crown, called escheatment. All right? This is taken from William Blackstone's commentaries and the majority opinion 2 out of 4. On the other account, all right, the clause adopted a distinctly American settler's view, of citizenship, okay? One that promises the full dignity and glory of American citizens to any children born in this country, to parents who have made this nation their permanent home, regardless of their race, religion, or national origin. So you see the two applications of how the 14th Amendment is being applied, okay? You got one going all the way back to our ancient ancestral customary form, and then you got the new form that they adopted and put on us when it's not our way of life, okay? Very, very important to understand your genealogy, your ancestry, because if you want to be a citizen, this is what it depends upon. We can go to Enway Ahmad Hassan to clear this up. Enway Ahmad Hassan, a district court case, 1942. Okay? To summarize the approach which must be followed in deciding whether a particular person is applying for citizenship is a white person within the meaning of the statute, which is the 1790 Naturalization Act, as interpreted by the Supreme Court, it is necessary to determine first the particular group or racial subdivision to which the individual belongs. In practical effects, proof of this fact is a matter of genealogy. An individual who presents the aberration from the color of skin of the group of which he is a member, such as a light-skinned Chinese or a Japanese or a dark-skinned Anglo-Saxon, does not thereby acquire a different status under the act from other members of his group. Of course, when the individual applying for citizenship has a skin of a different color than is usual for the members of the group from which he claims to come, a strong burden of proof then rests upon him to show by the usual methods of proving genealogy that he is in fact a member of that group. After the individual has first been traced into his group, the second question which the court must answer is whether the member of the group as a whole or a white person as Congress understood it in the term of 1790 when it first enacted the said statute, the Naturalization Act of 1790. And deciding the latter question, in regards to the statute, the test is not how the group in question would be classified by ethnologists who have made a study of racial origin, but rather which group of people then living in 1790 were characteristics then existing were intended to be Congress to be classified as white persons. Applying this principle, the court finds that the petitioner is an Arab, and the Arabs are not white persons within the meaning of that said act. Okay, so if that is in fact the case, then we could not be citizens under the Naturalization Act of 1790. Nor can we be citizens under the 14th Amendment, because the 14th Amendment are enumerated laws that they created and put in place to preserve some rights that they gave to us, which are not the rights that we retained, which were unenumerated. Why? Because these laws that we retained, which were unenumerated, were a customary law going back to what we call folk right. Okay? Folk right, in which the founding fathers took it for themselves. How I know it, Juan Kim Ark said. Let's go back to Juan Kim Ark. All right. Juan Kim Ark. Too far. This is in closing. Before the revolution, the view of the publicists had been thus put by Vattel. The natives or natural born citizens are those born in the country of parents who are citizens. As society cannot exist and perpetuate itself otherwise than by the children of the citizens, those children naturally follow the conditions of their fathers and succeed to all their rights. The society is supposed to desire this in consequence of what it owes to its own preservation. It is presumed as a matter of course that each citizen or entering into society reserves to his children the right of becoming members of it. The countries of the fathers is therefore that of the children, and these become true citizens merely by their tacit consent. We should soon see whether, on their coming to the years of discretion, they may renounce their right and what they owe to the society in which they were born. I say that in order to be of the country, it is necessary that the person be born of the father who is a citizen, for if he is born there of a foreigner, it will be only the place of his birth and not of his country. Okay? Y'all hear that? The true bond which connects the child with the body of politics is not the matter of an inanimate piece of land, but the moral relation of its parentage. The place of birth produced no change in the rule that children follow the condition of their father, for it is not naturally the place of birth that gives rise, but extraction. To what nation a person belongs is by law of all nations closely dependent on descent. It is almost a universal rule that citizenship of the parents determines it. That of the father where children are lawful, and where they are bastards, that of their mother, without regard to their place of their birth, and that must necessarily be recognized as the correct canon, since nationality is in the essence dependent upon descent. Okay? The framers of the Constitution were familiar with the distinction between Roman law and feudal law, between obligations based on territoriality and those based on personal and indivisible character of origin. And there is nothing to show that in the matter of nationality, they intended to adhere to the principles derived from the regal government in which they just had existed in what? Overthrowing. Manifestly, when the sovereignty of the crown was thrown off, and the independent government established every rule of the common law and every statute of England obtained in the colonies in derogation of the principles on which the new government was founded was abrogated. The state for all national purposes embraced in the Constitution became one, united under the same sovereign authority and governed by the same laws, but they retained their jurisdiction over all persons, i.e. the slaves, and things, i.e. their property, within their territorial limits, except where surrendered to the general government or restrained by the Constitution, and protection to life, liberty, and property rested primarily with them. So far as the just commune and folk right related to the rights of persons was concerned, the colonies regarded it as their birthright and adopted such parts as they found applicable to their condition. Did you hear that, brothers and sisters? They took it as their own birthright. Now let's go to Anglo-Saxon law. Anglo-Saxon land law. So they took the folk right. They said the founding fathers, the colonists, took the folk right as their own. That's what it just said. All right. And the Anglo-Saxons became English people when united by Alfred the Great. Okay. This is the Anglo-Saxon law. Doom, decree, judgment was the legal system of the Anglo-Saxon England from the 6th century until the Norman conquest of 1066. It was a form of Germanic law based on unwritten custom known as folk right and on a written laws enacted by kings with the advice of their wittin or council. Once again, they're not Germans because the Germans were the ones that Frederick Douglass said that were, what do you call them, rude boars, which we'll close on in a second, okay? It said that by the later period, Anglo-Saxon period, a system of courts had developed to administer the laws, while enforcement was, I missed one. It said it was form of Germanic based on unwritten custom known as folk right and on other written laws enacted by kings with the advice of the written of council. So they're saying that the Anglo-Saxon law is called folk right, and the folk right was written by Witten. We know Witten, those are Wittemont, which are clearly was the verb from the 1911 Encyclopedia Britannica. But just to be sure of it, when you said that they were Germanic people, then that's not what Benjamin Franklin said. Let's go to it. Benjamin Franklin. Now check this out. All right. Until the American Civil War and Reconstruction. Until the American Civil War, slavery was legal. Once again, until the American Civil War, slavery was legal. Until the American Civil War, slavery was legal. After the American Revolutionary War, the United States Congress passed the Naturalization Act of 1790 to provide a way for foreigners to become citizens of a new country. Once again, why is this not showing? I'm trying to share my screen, but it's not sharing. Can you see my screen? Give me 1 second. Okay, good. All right. It said until the American Civil War, slavery was legal. After the American Revolutionary War, the United States Congress passed the Naturalization Act of 1790 to provide a way for foreigners to become citizens of a new country. Okay? It limited naturalization to aliens who were free white persons and thus left out indentured servants, slaves, free African Americans, and later Asians. So that means that under the Naturalization Act, white people, according to what Benjamin Franklin clearly pointed out, was those who became citizens by way of the Naturalization Act of 1790, and it clearly pointed out that this Naturalization Act was for those who were foreigners, okay, to become naturalized and they be identified as free white persons. It just said that, didn't it? It just said that. Okay, if it just said that Naturalization Act was for foreigners, okay, identify as free white person. What is a alien? What is an alien? Pull up the word. I knew I had it up here. Right here. What is an alien? Alien. In law, an alien is a foreign-born resident who has not been naturalized and is still a citizen or subject of a foreign country. Although definitions and terminology differ across legal systems, so an alien is a foreign national, and as he just said, the foreign nationals were known as free white persons, okay, under the Naturalization Act of 1790. That's what it just said. So somebody has a lot of explaining to do. Let's go back to observation. Let's go back here. Let's see what Benjamin Franklin has to say as well about the Germans, okay? Right here. All right. Anti-German sentiment. While the essay was an important contribution to economic and population growth, recent attention has focused on the final two paragraphs. Franklin was alarmed by the influx of German immigrants to Pennsylvania. I thought you just said that the Anglo-Saxons were of German descent. Can you just say that? And that they will be identified as free white person, which clearly points to foreign naturalized aliens, okay, under the Naturalization Act, which does not need a genealogy test like the dark-skinned Anglo-Saxons stated in Ray Hassan. Did anyone of you catch that? Probably didn't. Franklin was alarmed by the influx of German immigrants to Pennsylvania. The German immigrants were lacking in a liberal political tradition, the English language, and Anglo-American culture. In paragraph 23 of the essay, Franklin wrote, "Why should the Palatine Boers be suffered to swarm into our settlement and by herding together establish their language and manners to the exclusion of ours? Why should Pennsylvania, founded by the English, become a colony of aliens who will shortly be so numerous as to Germanize us instead of our Anglifying them, and will never adopt our language or custom any more than they can acquire our complexion?" Now let's go back to what they said. Anyway, Hassan said the complexion of the Anglo-Saxons. He said dark-skinned. Right? If you're not going to play the skin game, and there's a genealogy test to prove genealogy, then they're not white-skinned, they're dark-skinned. All right? If you want to play that game. All right? You can't make this up. All right? The Anglo-Saxons are not Germans because the Germans would not be dark-skinned. They will be white-skinned, like you said. Okay? Let's prove you said it. Let's prove what he said. Trimber finds that Franklin Maine's concerns over the growth of unassimilated Germans is the threat to Anglo-American culture and the English language. This becomes racial when Franklin concocts categories of his own invention. Franklin favored immigration of Anglo-Saxons. Okay, you hear that? Franklin favored, this is one of the founding fathers who stole our folk right. Franklin favored immigration of Anglo-Saxons who, according to Ummer's survey, he identified as the only white people among the various people of the world. Let's go back to where we just read that at, Imre Hassan. So why would the judge throw a hypothetical question saying dark-skinned Anglo-Saxon does not thereby acquire a different status under the act from other members of his group. Of course, when the individual applying for citizenship had the skin of a different color than is usual for the member of the group from which he claims to come, a strong burden to prove that rests upon him to show that the usual method which is proven genealogy, that you are in fact a member of that group. They said dark skin, not light-skinned. So why would Benjamin Franklin say that they were light-skinned or fair-skinned, which denotes the Caucasoids? Okay? Why would he say that? Okay? Franklin favored immigration from Anglo-Saxons who, according to on survey, he identified as the only white people among the various people of the world. Although such an idea would have been highly unusual at the time, and Franklin never mentioned race at all but complexion, nor does he deny that the Germans belong to what? The white race. Okay? The white race. Come on, brothers and sisters, you cannot make this up. My teachers are profound. Okay? They are sound and profound. Okay, where was I at? Let me just go here. Legal fiction. A legal fiction is the constructed use of in law where in order to facilitate a specific outcome, a position is taken to be true even if such position is not literally true. Legal fictions can be employed by the courts or found in legislation. Legal fictions are different from legal presumptions, which assume a certain state of fact until opposite is proven, such as the presumption of legitimacy. Okay? So there's such thing as a legal fiction, something that's false is accepted as a fact in law and cannot be challenged as a result of the reason why the legal fiction was created, versus legal presumption, something assumed to be a fact until proven otherwise. Okay? This brings us to what we call legal persons. Okay? Legal persons, which we call persona ficta. Okay? What are legal persons, which you know as legal fictions? Okay? In law, a legal person is any person or legal entity that can do the things that human persons usually able to do in law, such as enter into contracts, sue and be sued, own property, and so on. Okay? Once again, in law, a legal fiction or a legal person is a legal entity. An entity created by law, because legal has to do with something that is lawful. Okay? So that means that the entity is accepted in law as fact, even though the entity itself is false, because it is a legal person, a legal fiction, something that's not real that can do the things that real people can do, like sue, be sued, own property, do contracts, whatsoever. Okay, we call that persona ficta. Okay, persona ficta. The Roman Catholic Church called it the vicar of Christ. Once again, persona ficta or the vicar of Christ denotes to an office or a capacity. Okay? Legal person is a prerequisite to a legal capacity. The ability of any legal person to amend, i.e., enter into, transfer, etc., rights and obligations. It is a prerequisite for international organizations being able to sign international treaty in its own name. Okay? History in the origin of legal person. Where did it come from? The doctrine has been attributed to Pope Innocent IV, who seems at least to have have helped spread the idea of persona ficta, as it is called in Latin. In canon law, the doctrine of persona ficta also allowed monasteries to have a legal existence that was apart from the monks, simplifying the difficulty in balancing the need for such groups to have infrastructure, though the monks took vows of personal poverty. So we see that the origin of a legal fiction or a legal person goes back to the origin of the term, or the Latin term, persona ficta, which has its origin in Pope Innocent the Fourth. If you go 4 popes before Pope Innocent, you come to Pope Innocent the Third. Okay? And we know Pope Innocent III, even though he was a Roman Pope, he declared the capacity of the English Church to be free. Okay? To be free. Pope Innocent III declared the English Church to be free, and he also created the office of Vicar of Christ. Let's look at it. Come on. Okay, right here. The title is used by Roman Messiah in their prayers for the dead Pope and the oath of allegiance to Saint Boniface to Pope Gregory II. We know who was the founder of the Gregorian mission, Pope Gregory I. Okay? Pope Gregory I. All right? Commissioned by Augustine of Canterbury, Pope Augustine of Canterbury, to have Pope Gregory commissioned Augustine of Canterbury to have the Anglo-Saxons convert to Christianity. Okay? So we see that it says since 1200, popes have consistently used this title, insisting that he and he alone had the right to remove bishops from office. Pope Innocent III appealed to the title of what? Vicar of Christ. Okay? Vicar of Christ. It is an office, brothers and sisters. An office. Vicar of Christ is a term used by different ways and with different theological connotations throughout history. The original notion of vicar is an early representative of Christ, but is also used in the sense of a person acting as a parish priest in place of a real person. The title is now used in Catholicism to refer to the bishop, and more specifically, was historically used to refer to the Bishop of Rome. Okay? So we see it is in fact a legal office. Okay? We call it the crown, or a corporation soul. Okay? Very important. This is why the third declared church shall be free, because it has a different than the Roman Catholic Church. Okay? Very, very important. And we can prove that right here. Anglo-Saxon law. Let's see if I can pull this up. Anglo-Saxon land tenure. Land tenure. You gotta know what you're talking about, brothers and sisters. Okay, let's see. Okay, right here. Okay. Right here. I told you who created the legal fiction, i.e., legal entity, i.e., legal person, i.e., you call it straw man. It's right here. Even before the Norman conquest, there was a strong tradition of landholding in Anglo-Saxon law. Okay? When William the Conqueror asserted sovereignty over England in 1066, he confiscated the property of the recalcitrant English landowners. You hear that? Over the next dozen years, he granted land to his lords and to his dispossessed Englishmen, or affirmed their existing landholdings in exchange for fealty and promises of military and other services. At the time of the Doomsday Book, all land in England was held by someone, and from that time there has been no allodial land in England. You hear that? There was no allodial land in England. So New Jersey returned the land back to allodio. We can prove it through the statute, through the creation of what? A legal fiction. In order to legitimize the notion of the crown's paramount lordship, a legal fiction that all land titles were held by the king's subjects as a result of royal grants was adopted. Right there, brothers and sisters, right there. We go right into New Jersey by statute to prove it. I show receipts. Okay, where was I at? All right, right there. All land is allodial. Okay, gift grants conveyances by the state is allodial. It was back then till William the Conqueror, invaded it and made it all feudal. All right, and it remained feudal all the way up till March 12th, 1668, right here. 4613-2. So everything William the Conqueror did ended right here on this date, March 12th, 1664. It was over. Okay? Once that feudal era ended, it returned back to allodial. Right? But someone has to fit that capacity. That legal entity. Where's the legal entity? Okay, we just said that Anglo-Saxon law was created through a legal fiction, a corporate entity, a legal entity. All right? That is a capacity, a legal capacity that you can't get from Title 46. Title 46 is the interest, not the capacity. For the capacity of the king, all right, and the king is head of the church, i.e., the English church, then you must go to the proper capacity that's recognized in modern day law. Okay? In modern day law, where's the capacity, brothers and sisters? Just look at the statute. Look to the law. Look to the law. Right here. Saving rights of charters of Great Britain, being Section 12 of an act and to incorporate trustees of religious societies Improved April 9th, 1775. Saved from repeals. This section vested property held on the charters of incorporation granted by Great Britain and incorporation in place thereof. So the capacity is here. I mean, the interest is here. The interest we have is property, which is governed under Title 46. But in order for you to have that interest in property governed under Title 46, you must have the capacity, and that's through 16:1-28. Okay? The capacity. All right? Very, 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 very important to understand the capacity that we have as English people. Okay? And with that, let's see. With that, I rest. I hope the information that I've given you will help straighten out your concepts about citizenship in lieu of capacity and interest, which is the land. Okay? And inherit the land, whether it comes from your people, or whether it comes from God, or whether it comes from them, you need to prove that you have an interest in it. And you can only do that with the proper understanding. Okay? With the proper understanding. Let me make sure I covered everything. Yeah, I did. So with that, I'm going to stop. And is there any questions in the chat? Let me see if I can hook that up. Are there any questions in the chat? Any any questions? Are there any questions? Let's see. I guess that's it. Okay, brothers and sisters. Love you all. I'll see you at the next lecture. Talk to you soon. Peace and love.